Okay, we're back on the record on Ms. Villa's case here. Counsel, thank you very much. The court will take judicial notice of the records and files relating to this case, which include the pre-sentence report, the recommendation, the letters of support on behalf of Ms. Villa, and also the documents submitted by the state this morning. What is the appropriate sentence? What are the facts in this case? This was a difficult trial. Counsel, both of you folks fought hard representing your points of view or your theory of the case. This was not easy. Lots of interest in this case. But what are the facts that we all heard through this trial? That drives the decision this morning. You folks we talk about the sentencing factors as a court to consider. Of course, they are appropriate matters for the court to consider, which you both argued this morning, pointed out to the court as to why and what the sentence is the appropriate sentence in this case. The medical testimony is the most important. It's clear. The medical testimony in this case is clear. It's on the record. It's on the record as to how the cause of death in this case. The facts, also all the other facts. After they left our line, he went back to the hotel, then back to Miss Villa's house. And Miss Villa, the defendant, had full custody of baby Abby and the rest of the other kids. They slept through the night. Next morning, baby Abby was unresponsive. The amount of Benadryl found in the blood system of Abby, the medical testimony is clear as to that. The amount that should be given to any minor, much less a minor, a baby about 7 months old, so forth. That drives. Those are the facts in this case. So, I mean, the counsel, you both talk about 706-606 and 706-621 as to the factors that this court consider. Of course, these are the facts the court must consider. As the prosecutor walked through each and every factor under 606 as to why the 20 years is appropriate. On the other hand, the defendant is requesting this court probation because she has minor children that requires or need her attention. But based on the factors that the prosecutor pointed out, the facts and the law here is clear. This should not have happened. The factors that the prosecutor lay out, 606, 1, 2, and all of the factors, 2A, B, C, and D, 3 and 4. These are the factors that the court has to consider, as well as on what is appropriate. And the only sentence that stand out for this case is the defendant must be sentenced to 20 years of imprisonment, made to issue forthwith, with credit for time where appropriate. And I know this court has to consider probation, and the court has been since the ending of this case, reviewing the notes, reviewing the facts of this case, the testimony from these particular witnesses, but more so the medical testimony is what does really hold this case together. So, Ms. Villa, I'm sorry, but probation, the court cannot, based on the factors that your attorney and the state solicitor, the court cannot place you on probation at this point. So the court has sentenced you for an open term of 20 years, made to issue forthwith. Waive all the court costs. Secondly, Ms. Cow, the court also has received of your motion to withdraw. Anything from the state? No, sir. All right, based on the court's review of the motion, the matter, counsel's motion to withdraw is granted, and defendant referred to the public defender's office for appointment and or them handling counsel for appellate purposes, and that is the next step as is appropriate under the law. Okay? Anything else, counsel?
No, thank you.
Okay, thank you.
Thank you, Your Honor.
Monty, anything else? Nothing further, we are adjourned. Thank you.